My name is Brian Corvo. I'm Assistant Counsel at CBIA. Welcome to CBIA's HR Hotline Live webinar. Today you'll be hearing from Mark Soycher, who's here to answer questions about labor and employment issues in the COVID-19 landscape. For the next hour, you'll have the opportunity to ask questions and learn about labor and employment issues in the COVID-19 environment. Many of you have already taken the opportunity to submit questions in advance, and we're going to start with those. Please use the Q&A function located in the middle of your screen to submit your feedback and questions at any time. As this is an evolving area of law, there may not yet be definite answers to every question. Please note that this session is being recorded and will be posted at cbia.com. To begin, I'd like to introduce Mark Soycher, although to many of you, he needs no introduction. Mark Soycher is CBIA's Human Resource Counsel and has, for the past 20 years, through CBIA's HR Hotline, guided Connecticut employers through the maze of workplace laws and regulations, providing legal assistance with all employment issues ranging from hiring to firing. Mark, welcome. Good to see you.
Thanks, Brian. Good to be here.
Last week, I had the opportunity to help CBIA members with their HR and employment issues while you're on a well-deserved vacation. And vacation is actually a great segue into our first group of questions. Many of the questions I answered last week and many of the ones that were submitted in advance of this webinar involve situations where employees are taking summer vacations and choosing to travel to COVID-affected states. The issue arises when the employees return from vacation and they can't return right to work because they're subject to a mandatory self-quarantine pursuant to the governor's executive order. So I have two questions here. First of all, do employers need to pay the employees for another 14 days they will not be in the workplace? I'm hoping there you can explain maybe how the FFCRA will cover such paid absences. And then secondly, employers want to know what they can do to dissuade employees from traveling to these places in the first place and prevent these extended absences from the workplace. What can they do? Should they have a policy in place? Can they deny vacation time to a hotspot? Can they even inquire about their employees' travel plans?
Okay, well, the answer to the first question, and I'll circle back to that, if an employee is quarantining because they've traveled to a state designated as a high risk or hot state, that leave of absence for the 14-day self-quarantine period would qualify for the emergency paid sick leave benefits under the Families First Coronavirus Response Act. That's a sticking point for some employers because they're thinking, it's bad enough I'm losing the services of this individual. They're out for another 2 weeks. It's an extended vacation for 2 weeks, and now I have to pay them. Well, the focus should be on the rest of the workforce and the workplace, which is the intent of that law, to facilitate employees staying away from work when they otherwise might present an infection risk to others in the workplace. So as disconcerting as it may be to be paying someone when they've voluntarily made a decision to go to a place where it's inadvisable, that's not the purpose of the law, but my comment to employers is get over it. Sidestep that one and just don't think about it too much, because the purpose really is the greater good of the health and safety of the rest of the workforce. As far as trying to dissuade others from traveling, I think it's appropriate for employers to ask employees about their summer vacation plans. Be respectful that everyone does need some time to get away. I did the last 2 weeks. I was in Rhode Island. We didn't go anywhere other than where we stayed in Rhode Island and tried to limit our interactions with others. But a change of scenery can be very refreshing. But employers can tell employees, here's the list of the states that are inadvisable to travel to. If you travel to any of those locations, your return to work may be delayed by up to 2 weeks. And that's required under state law. It's not a discretionary matter on our part. So employers can, send messages to employees that this is not the year to make that trip to Florida for a 4-day weekend for a clam bake on the coast, simply because it looks really nice to do. The reality also is an employee going to, get a loaf of bread from the supermarket could be exposed as well in their own neighborhood. So, appropriate hygiene practices and face coverings and hand sanitizers, things like that are critical to continue to follow even in one's own home community. The employer does not have to follow up that message about please don't go to those states because you may be delayed in coming back to work. They don't have to follow that up with, and you'll be paid for the 14 days that you can't come back to work. But employees are going to figure that out anyway. The tagline that I would add to that is, don't think of that as an extended vacation with pay for another 2 weeks, because that may be spent in the emergency room, or it could be spent looking at grandma in the emergency room because you've come back because of a poorly made decision about traveling and brought back some illness to the family or coworkers. So employers definitely need to comply with that state travel advisory. There are penalties built into it. I don't know how aggressive the state will be in fining people $1,000 who don't report back their travel and self-quarantine. But there is the possibility that a coworker looking over their shoulder and seeing someone with a nice tan and says, I know where they were the last couple of days. They haven't said anything, but their pictures of that little jaunt are posted on their Facebook page. So I'm going to file a complaint with the state, which anyone can do. And that complaint could be filed against both the worker and the employer. And the last thing an employer that has worked diligently to maintain health and safety in the workplace wants to see is a news report about their failure to comply with the restrictions on the self-quarantine.
Certainly. When, let's say an employee comes back and they say, I have to quarantine for 14 days now. I can get this, I can be paid through the FFCRA as you mentioned. Can an employer say, you know what, I have some work for you to do at home. I have either some data entry work or light work. You can work from home. Would that trigger an exception to that?
Well, that would be an opportunity for that employee to save a portion of the emergency paid sick leave period. If they're able to work remotely, the employer is assigning them work remotely and paying them. In the U.S. Department of Labor's series of FAQs on the paid leave, whether it's emergency paid sick leave or the expanded FMLA leave, if the worker is given an assignment to work remotely and can do so effectively, and the employer is paying the person, then they're not eligible for that paid leave. They're simply continuing to work, albeit at a remote location. And that could be continuing to work even if they feel some symptoms of an illness. If they're still capable of working, then they're working, albeit remotely. So that wouldn't even fall into the coverage of the Fair Credit FFCRA.
Here's another common question we've had from some employers who are going through this is, how do they, are they actually, is the employer responsible for making sure that the employee is self-quarantining, and how would that be tracked or enforced? They want to know if they have any liability in that.
Yeah, I don't think that's the employer's responsibility. I think the employer's obligation should extend to the property boundaries of their workplace, and not try to regulate employee conduct outside of the workplace. But the enforcement mechanism, the state has on its advisory page for the travel advisory a link to a health form, which if someone's coming through an airport, they're going to be confronted with that a little bit more directly. If they're traveling on the highway, if they've driven, and many of those states are within driving distance, there are probably some highway signs that say, if you're coming from any of the states, and they'll have the website maybe, so people can check on that, you are obligated to self-quarantine and fill out a form. The form asks for your name, contact information, and address. and indicates that if you have been to one of those states, you must report. You file this form either by email or text to the State Department of Public Health. And the state does say that they may be following up. I don't know if they will or not, but it's possible that individuals may be called at the location they say they're going to be. And if they're not there, it's very possible the state could go after them and assess the $1,000 fine against individuals that fail to comply. But it's really the individual worker or traveler's obligation to self-quarantine, remain in a location, and not be out and about and saying, hey, I'm self-quarantining in my neighbor's backyard, in the local watering hole, and swimming pool, things like that. That's just irresponsible.
The next set of questions we got have to do with there's a testing option where employees who, or anyone who's traveled to one of these spots can come back and get tested. So the question is, can an employee with a negative test return to work before the 14 days? And can the employer, if so, can the employer require the employee to take that test as an alternative to quarantine?
Yeah, there was some confusion over that from the initial rollout of this travel advisory. And even the governor at some point had said in one of his press briefings that he thought a negative test would be a satisfactory alternative to the self-quarantine. However, if you look closely at the FAQs on the state's website, the reference to testing as a strategy for someone to return to work sooner than the 14-day quarantine period is tucked within a sentence that says, if self-quarantine is not available or not possible, then a negative test within 72 hours of traveling may be an acceptable alternate means of addressing the safety issue for the rest of the workers and the workplace, but only if self-quarantine is not possible. I'm not sure what circumstance might be that self-quarantine is not available or not possible. Seems to be a very narrow category of circumstances. So those that see a negative test and they're, waving that piece of paper that says, I got a negative test, here's my ticket to get back to work, I think are inappropriately trying to use that strategy when self-quarantine in just about all cases is going to be a feasible step to take. And we're talking about percentages of risk here. And so it's not an all or nothing proposition. But I do think that to try to sidestep the quarantine period to 2 weeks away with pay, as we've suggested, is the best alternative, because that's the incubation period for the COVID illness. And I think it's important also to think about the fact that a test only reveals someone's health status up to the point of the test. So if someone has traveled within the last couple of days and they have a negative test, they may still be in the incubation period. So the test says today they're negative. Let's roll forward a couple of days. I think it was Mike Pence's press secretary who had a test one day, was negative. Everything was fine. The next day she was tested again. She was positive. So it's not as reassuring a strategy. One of
and just on the topic of self-quarantine, just to people while they're quarantining can remotely work if possible or feasible, and that can be done. I wanted to clarify that for somebody.
Yeah, absolutely. To the extent that people can work remotely, that's simply continuing to work, and people will earn wages during that period of time. I just want to point out the governor's travel advisory and the FAQs also make reference to another exception to the self-quarantine for those employees of essential businesses or essential industries. And while that also was the subject of some initial confusion, it was clarified. And in the FAQs, it clearly says both that the travel must be business related and that vacation travel is not an acceptable exception if the person works for an essential business. So if somebody has to go down to Virginia to pick up a key part for a piece of equipment that can't be shipped quickly enough. So they're going to drive down, they're going to come back and bring it back here. That's a business trip related to the essential industry or business that they work for. And that would enable them to come back to work sooner. Although if quarantine is available, I would still suggest an employer consider insisting the person quarantine. But if they're going for a purely social occasion, it's a reunion trip with their high school buddies, but they work for an essential industry, that still necessitates the self-quarantine.
And similarly, just to I believe it's the same guidance, even if business travel isn't necessary, it should be, it should probably be avoided to satisfy that.
Yeah, I think, many businesses, most businesses have gotten really good at video meetings as we're doing right now. And so it's rare that the occasion will arise where someone absolutely has to be in person at a meeting, even within offices. The guidance in the reopening guidelines that took effect May 20th indicate for non-essential businesses, people that are returning to the workplace, they should segment the workplace and people should move about only in areas they need to as part of their job, rather than strolling around and saying, hey, I haven't seen you for 3 months. How are you doing? Let's sit down and chat. To the extent that can be avoided, that's advisable.
Touching back for a second on the issue of testing, can an employer require a negative test before allowing an employee to return to work after travel?
Yes, an employer can. The question arose not just with testing, but taking temperatures, asking employees how they're feeling, if they've experienced symptoms, things like that. The EEOC has issued guidance on a lot of these aspects of this whole situation, and clearly stated that those types of inquiries or requirements are considered a medical inquiry, which in normal times would not be permissible under the Americans with Disabilities Act. But in a COVID pandemic context, where the illness poses a direct threat to the workplace and coworkers, some degree of medical inquiry is permissible because, again, it's focusing on symptoms rather than an actual having an illness. And so employers can either require tests, require temperature taking, or other questionnaires that employees respond to that. It's interesting that the EEOC distinguishes between a COVID test and an antibody test. The antibody test is not evaluating whether someone is ill and presents a threat or not. It's evaluating a medical status, whether someone has had an illness. And the EEOC says that an antibody test is not a permissible inquiry as a gateway measure whether to allow someone to return to work or not. But a COVID test could be, because that's measuring current health status, which could pose a direct threat to the workforce.
Absolutely. And we're going to go into that in a little while, because we do have some questions on that. Before we get there, just a lot of the questions that I was fielding while you were away, and it was actually a lot of fun. I learned a lot, and a lot of the questions that came in for this webinar really a lot of them have to do with issues that are addressed somehow by the FFCRA. So I was hoping we could take maybe a deeper dive into that for a couple minutes, Mark, with some general FFCRA questions. Briefly, I was wondering if you can start out with what size employers does the FFCRA apply to, and what sorts of situations does it cover?
Well, it's been a sobering reality for the smaller businesses, the under 50 population companies, because previously they've not been subject to the Family and Medical Leave Law. And so the Families First Coronavirus Response Act, FFCRA, does apply to the smallest of companies. And it applies to companies up to as large as 500 employees. So that encompasses the vast majority of businesses. throughout the state of Connecticut. It's interesting under the federal guidelines. I think a small business is defined as an organization with 500 or fewer employees. From my experience, companies with several hundred employees are not small businesses. They're relatively large for the Connecticut landscape. But 500 is the cap for the FFCRA. Above 500, while they're not obligated to provide the emergency paid sick leave or expanded FMLA leave, they are still subject to both the state and federal FMLA leave laws. And so that job protected leave in some context may be required, albeit in the more narrower circumstances covered by the FMLA, not the expanded, broader circumstances covered by the FFCRA.
A few questions that have come in just while we were preparing for this, and it's come in from a couple different employers, is what if you're on the borderline of having 500 employees, and during the time an employee is out on leave that's covered by FFCRA, you go over 500 employees, or you were over 500 employees and someone needs to go out and now you're covered by the FFCRA. To me, that's like a law school question because you just had a fact change halfway through.
Well, you plucked one out I haven't had before and haven't even thought about. But
I don't know the answer to that either.
What I would immediately jump to is the circumstances where under classic or traditional FMLA provisions, a company would have grown or shrunk, for example, so that initially they had 50 or more employees through a series of cutbacks. They reduced their workforce and now are not subject to the FMLA. I would say someone's benefit entitlements should be established at the time they commence the circumstance or the leave that triggered the application of the law, and would continue to apply even if the employer then fell out of coverage by virtue of growing above 500 employees. And in the reverse situation, I would say they would probably be wise to expand the benefits available to someone if the company shrinks into coverage of the law, because, for example, if an employer was not subject to the FMLA, or if someone had worked for an employer for less than a year, so they were not yet subject to the FMLA and took time off for a serious health condition, and then during the time that they were out with a serious health condition, they passed their 1-year anniversary. Their leave after that 1-year anniversary period would be covered under the FMLA, and the employer could not count the time of absence prior to their eligibility against their entitlement under the FMLA. So bringing in a little bit of the traditional FMLA law to kind of superimpose it and come up. And good faith efforts here will wear very well on an employer if someone then complains to the Labor Department that they're being denied something, if the employer said, we did our best. And I think in these contexts, because most of these leaves are not simply to accommodate individuals' personal needs, but rather to address workplace health and safety as well, I would urge an employer to err on the side of safety. The one point I would make is that if an employer is issuing paid leave benefits to someone during a time when they're not otherwise subject to the law, it's fine to give that leave to them, but they may not be able to recover that through the payroll tax credit because the IRS at some point might be auditing these tax credits that companies are taking. And if the company can't substantiate their coverage under the tax credit provisions of the FFCRA, it may be an impermissible tax credit.
In the event that an employer isn't covered by the FFCRA, so they're over 500 employees. To go back for a second, somebody comes back from Florida. What are the options for that employer to do with that employee? They're not in FFCRA land. but they can't have this person back in their shop or their office or whatever. What do you do if you're not covered by that?
Well, there are still some financial safety nets available. In many cases, companies of that size probably have some fairly generous paid time off benefit plans. And so they could certainly require employees to tap into their accrued PTO time, whether it's additional paid vacation, personal time, possibly sick leave, depending on if they allow use of sick leave if someone is ill or not ill. If someone is experiencing COVID symptoms, it's possible they might qualify under a short-term disability benefit plan if they can substantiate medical incapacity related to COVID-19. But if, on the other hand, it's someone who has thankfully dodged the virus bullet and but nonetheless is told to stay home for 14 days, and you're not eligible for the FFCRA emergency paid sick leave, they could apply for unemployment benefits. The person could properly represent to unemployment that they are able and available to work, but they're being told by their employer they can't work. On the other hand, the employer could say they're not capable of working because there's this governor's executive order that says we are not permitted to have this person in the workplace. Well, the Labor Department has addressed that through some of the federal funding for the unemployment system. I'm not talking about the $600 that everyone is waiting anxiously to see what Congress does, but rather the extended unemployment benefits under what's called the PUA, the Pandemic Unemployment Assistance. That provides for some additional unemployment benefits administered by the state Labor Department, either for people who are not available or able to work, and they may have to apply to state Labor Department for unemployment, be rejected, and then be directed to reapply, and it'll be processed under the federal guidelines and funded by the federal government. So the eligibility for those additional benefits will be provided when people are subject to a state quarantine order or other COVID-related circumstances, and payment of those benefits won't be charged back to the employer that they're working for. So there are some mechanisms there. Those pandemic unemployment assistance benefits also provide an extended 13 weeks to the basic 26 weeks worth of benefits. So for an extended period, those I believe are in place until 12/31 this year, the end of the year. And Congress also, there's been some chatter about looking at extending that into 2021 if that becomes necessary.
Let me ask you this, just and it's an issue that's come up a couple times. A lot of employers want to know what the limits are under the FFCRA. How many times can an employee use this? Can you go to Florida, come out of quarantine, and you still have some paid time off, work for a week, and then go to a crab shack in Maryland, come back and quarantine for 2 weeks? People want to know what the limits are. Can you take the unpaid time more than once?
Presently, that's pretty easy. Actually, it's a one-time deal. The FFCRA provided for paid leave for an initial 10 days or 80 hours, depending on what the person's normal work schedule is. But that's a paid 2-week period available to someone at 100% of pay when it's related to the individual's own health status. So they're experiencing symptoms, they have gone for a test, they've been diagnosed, they get 100% of pay to stay away from work for 2 weeks, and that's it. If they use that up and then they travel, they use that up, they return to work, they're healthy, they go for that clam bake because they're feeling good and relieved that they're healthy, and they come back and they're told you got to stay away for another 2 weeks. They're not eligible for another 2 weeks of emergency paid sick leave. They would be eligible for unemployment benefits very possibly. So that's the safety net there to address that circumstance. The additional paid leave available under the FFCRA is under the expanded FMLA law, which provides for 12 weeks of additional paid leave time. And it gets a little hairy there to try to describe the coordination of the two. The first 2 weeks of emergency paid sick leave can be used also for caring for a family member who is advised to self-quarantine. That's at 2/3 pay. Can also be used when you can't come to work because your child's school, daycare, summer camp, childcare provider is unavailable due to COVID. That would be at 2/3 pay for those first 2 weeks. Then there's an additional 10 weeks that gets tagged onto that. That's only available for childcare purposes.
One of the questions that's come up with that is, do they have to use it all at once, or can it be staggered out or used intermittently with paid time off or something else? So they don't have to, in other words, let's say you had for the expanded family medical leave, you were able to you had childcare available on Tuesdays and Thursdays, but not Monday, Wednesday, and Friday. So you were free to work on, 2 days a week. Could you stagger it out in that manner?
Yeah, with agreement between the employer and employee, it is permissible to use that time intermittently, as with traditional or classic FMLA. If you think about the purpose for the leave time, the leave that's necessary because an individual is experiencing symptoms or has been exposed and by traveling to an inappropriate location. The intent is to quarantine for the incubation period to see if the illness surfaces. And if it doesn't, then come back to work. But to stay away from work for only 2 or 3 days a week and then come into work for the other 2 or 3 days is running counter to the purpose for that leave. Leave taken for childcare purposes is not so much to address the health and safety issue, but rather to address the compelling need that parents have to watch for the welfare of their children. And so it can be used intermittently with agreement of the employer and the employee. And therefore it could stretch out for a longer period of time.
And I believe there's actually something that is put out in the guidance with that, where they actually stress some flexibility with employers and employees in using that for this purpose. We have, if an employee says that they may have been exposed to COVID and they're awaiting test results, does an employer need to pay them while they were out, even if the test ultimately comes back negative?
Yeah, that would qualify for the emergency paid sick leave and might ultimately be a situation where they're using up less than the full 10 days if the test comes back negative, in which case then it would be permissible for them to return to work. But some employers have suggested in comments that, well, why should I pay them? Because they're just waiting for a test. They haven't been deemed ill. Well, but that's the time when you want them to stay away. Playing the odds here. Better to have them remain away from work. And the intent of that payment is not to punish the person for doing something or being somewhere or being exposed in some way. It's to protect the rest of the workforce. And so the law doesn't really take into account the mindset of the worker, whether they've gone someplace they shouldn't have or simply gone to the supermarket to get a quart of milk and now are experiencing symptoms. Both could result in an exposure that should be protected by virtue of paying the person while they're away.
One of the
now just one point there. Self-diagnosis does not qualify for the FFCRA emergency paid sick leave. So if someone says, I'm feeling feverish, I think I should stay away from work. Albeit, yes, it's probably a good idea. However, in order to be eligible for the emergency paid sick leave and to substantiate the employer's ability to recover that cost through the payroll tax credit, the Labor Department and the IRS do clearly say the employer should have some reference to medical advice. Initially, when visiting a doctor's office was considered a very difficult proposition, they said in the guidance that employers can't insist on a physical piece of paper from a doctor signed by the doctor and that type of thing. So a doctor's name and contact information is sufficient to back up.
I have one more on this, and then I want to jump into a pressing question. In terms of FFCRA, an employer doesn't necessarily just have to take the employee's word for it that, hey, I'm experiencing COVID symptoms and have to stay home, or I'm caring for a loved one that's under quarantine or something. What documentation can an employer ask for? And I think that's required for them to be able to get the tax credits. And I want to jump into another question.
Yeah, I think the documentation, as I alluded to a moment ago, should be at least, if it's the employee's own health that's of concern, who is the doctor that is advising? The statement should include that the advice is to self-quarantine because of COVID-related health concerns, and here's the dates for which the person should remain away from work at a minimum. If it's a family member or someone else the person is residing with, it should be a similar statement and identification of a health provider for that person who is co-residing with the employee. If they are remaining away because of child care responsibilities, the employer should ask for name of the child, the age of the child, because it's got to be a minor child. And interestingly, there's a reference in some, but it's not consistent, that if it's a child who is over the age of 14, there should be some additional statement as to the specific circumstances necessitating parental oversight for that older child, suggesting that an older child should be able to watch themselves. But the name of the child, the name of the facility provider, whether it's the First Avenue Elementary School or the ABC Child Care Center, or the so-and-so day camp, or even Aunt Margie, who normally would be watching my child, but she's 69 years old, and therefore because of health risks is not available for COVID. That's the kind of documentation an employer should have.
Bouncing back for a second to travel, can you, in going more theoretically, because there is a considerable amount of pushback from employers about employees traveling to COVID-affected states. And we had talked about, and I think where one of these questions is going is, it's beyond the employer, if they're under 500 employees, is going to get paid by the FFCRA. Ultimately, they're going to get that tax credit for the wages they may pay. But there's also, they're inconvenienced in that they have to do rescheduling, that they're down a person, that they might have to pay another employee or employees overtime to cover for this employee that's out. What are a practical, concrete solution do you think an employer can take, or a possible legislative fix for that kind of loophole, where an employer can take a stronger stance against an employee going somewhere?
Well, I think, as with many areas of employment law, employers' options are not defined by what the law says they can do. They're more often defined by what the law says an employer cannot do. And if the law says if the law does not say an employer can't do something, then the employer can do it. And so employers can take a fairly aggressive stance with the workforce, including gathering everyone together and saying, hey, folks, we have worked really hard to keep everyone employed. to keep earning an income, keep some revenue flowing into the company so we can keep this business going and provide jobs to everyone. Let's not toss it aside by getting cavalier or short-sighted with the success we've achieved thus far. So we are depending on people's good senses and responsibility in refraining from travel, refraining from hanging out in places they shouldn't be, from deciding to walk away from a gathering of people who are standing around in someone's backyard sharing a beer on a hot summer night, but no one's wearing a mask. Walk away from those situations so that we can all continue coming to work. And ultimately, as I suggested before, I think some of the accountability here is going to come from the general population. Employees who are going to rat out other employees, who are going to rat out employers who are not complying. And I don't mean judgmentally there. The mechanism is available to file a complaint with the state. And rather than an employer fearing getting tagged by the state with a fine, I think the greater concern is the public image of the company that may be reported in the newspaper when it's identified as a hot spot in a neighborhood because the employer was not responsible or the workforce was not responsible.
One of, and there's another question I'd like to circle back to, and it's kind of an interesting question. With regards to people working from home, do you have to keep offering work from home opportunities to employees that haven't been productive with working from home? Do you call them back and require them to come back because they're going to be more productive in the actual physical workplace, or can you? From
an HR perspective, this has been a dramatic learning experience. More traditional managers have resisted work from home arrangements because the feeling is if I can't see the person, if I can't reach out and touch them, how do I know they're working? And my comment there is often, how many times do you want to ask a question of a coworker who's only working down the hall? And we don't always get up and stroll down and look at them. Sometimes we pick up the phone, and how often do you get voicemail? Or you send an email to them or a text message, and how often is there a delay in the response time? So I think managers have become very much more skilled at managing remotely. And it requires defining the tasks that someone is expected to perform while working remotely, and working out, and oftentimes with the incumbent worker, how are we going to measure the production? And what's the expectation in terms of communications? If it's not a time-sensitive set of responsibilities, it may be that the person is okay if they go and make dinner, take the dog for a walk, do a load of laundry, go out for a walk themselves for a breath of fresh air, but nonetheless get the work done within the time frame expected. And from a wage and hour standpoint, then if it's a non-exempt employee, tracking those blocks of working time so that wages can be properly calculated. But if ultimately an employer concludes, I'm not seeing a whole lot coming from that person, and whenever I've tried to call them, it rolls over to voicemail, I don't hear back on the emails or text messages for a couple of hours, I don't think they're really doing a whole lot. An employer could pull the plug on that and say, your remote work assignment is coming to an end because you're not being particularly productive. I either need you on site because we have taken appropriate steps here, or I'll put you on a leave of absence, and it's not going to be a paid leave of absence because you don't qualify under the FFCRA.
Absolutely. With that, I want to pivot a little bit. We've covered people being out of the office. One of the issues that some employers are facing now is how to bring people back into the office in a safe way. So I'd like to turn to some questions on bringing employees back in and helping to keep a safe workplace in light of COVID-19. And one of the situations that's come up, and I'm sure you've dealt with it, is you have employees that are, I'll call it the reluctant to return bucket. And in some cases, it's an employee that has underlying conditions, and out of caution, they remain out of the workplace, and they've been out since mid-March. In this particular member's question, the employee was not laid off. The company's let him stay out until he feels comfortable coming in, but he doesn't. The employee hasn't shown an interest in coming back at this point. What are the employer's options in something like that? And I'll throw in another thing there. The employee still has 3 weeks of PTO and may be retiring.
Yeah. A lot of different pieces that are commonly present in the various scenarios that companies are facing. If an employee is staying away from work simply because they're overwhelmed with anxiety over the news reports that they're watching 24/7 while remaining at home, and they just think the world is coming to an end, they're fearful of going outside at all, much less coming into the workplace, that's not a covered situation under the FFCRA. I keep saying Fair Credit Reporting Act. Under the Families First Coronavirus Response Act, it's not going to qualify for emergency paid sick leave wages, certainly not for the expanded FMLA. The employer could certainly burn up whatever accrued PTO time the person has. Interestingly, over the course of the last several months, the Labor Department has evolved its criteria for how they address this situation. And on the Connecticut Labor Department website, there's a lengthy series of Q&As dealing with various unemployment issues. And what they've said is that certain high-risk individuals, those 65 and older or of any age and with particular health conditions that present a high risk should they contract COVID, could be much more serious than otherwise would be the case. They would not be able or available to work, but could qualify for unemployment benefits in those situations. And again, there might be some additional steps required to succeed in being awarded unemployment benefits, but that could be the safety net in those situations. For employers that suspect someone is remaining away from work simply because anxiety or they enjoy unemployment rather than wages, and up until now, the extra 600 has proven to be a soothing element in the status of individuals remaining away from work and getting unemployment. But if the employer feels strongly that this person really doesn't need to remain away from work, there is a process, again, on the unemployment website to file a notice with state employment security division, the unemployment folks, to challenge that person's eligibility for benefits, which would require documenting an offer of suitable employment. Here's the job, same one you did before, wages, benefits, work hours, etc. And I would recommend including in there a description of all of the steps the employer has taken to make sure that the workplace is a safe, secure environment to come in. Wearing masks, training everyone on proper cleaning protocols, rearranging the physical facility for distancing, those types of things, to establish that it is a suitable offer to someone to bring them back.
So basically just absent some kind of actual compelling reason not to come in, mere reluctance or refusal isn't enough to say, I got to keep you on remote. You have to have, the employee has to have an actual reason not to come.
And unless the employee is experiencing anxiety to the extent that they could get a diagnosis from a mental health counselor who will say they are experiencing severe anxiety that's incapacitating them and it's COVID related. Not sure where that would fall, but that is a realistic circumstance. One element there in your hypothetical, say the employee is over 65, and can an employer, from a benevolent standpoint, say, I don't want you back to work because you're in a high risk category? The EEOC has addressed that in their Q&As and indicated that age alone is not an acceptable factor to deny someone the opportunity to come to work. However, an
I
employer could reach out to that person and say, I understand you may be eligible for unemployment benefits because you're in a high-risk category. However, if you would prefer to come back to work, that would be a decision that would be up to the worker, not the employer.
I received today an interesting question that's a spin on this, and I'm hoping you can briefly say a word on it, because I promised the employer we'd get to it. A company has furloughed or laid off employees who belong to a union. The union contract requires that they return back to work in order of seniority. But the more senior employees also happen to be considered high risk because of their age and in some ways underlying conditions. So they have to call back their most vulnerable first pursuant to this contract. Do you have any recommendations for them?
Well, I would come back to what I said a moment ago, that age in and of itself, or even health status, is not a basis for an employer to deny someone the option of returning to work if the individual is capable and interested in doing so. It would certainly be advisable to initiate some conversations about the risks associated with COVID and various health conditions, including age, and urge employees to confer with their own health providers. But if an employee says, oh yeah, I had some respiratory problems years ago, but I've changed my diet, quit smoking, exercised, etc. Doctor says now at 72, I'm okay to come back to work. I would not advise an employer to lay down any further barriers to that person's returning to work. And a collective bargaining agreement, I'm not an expert in more traditional labor law, but I would say that it should be a considered factor, the criteria of the collective bargaining agreement. But there may be some circumstances where it could be set aside if there was some compelling reasons.
There's a second bucket of questions in employees coming back to work. And this is my first day. I came into the office today. And I know, just like everywhere else right now, that I may want to go, I have to wear a mask. And we talked about this internally, but what can an employer do if, and I've got this question a couple times submitted, what can an employer do if an employee refuses to wear a mask? And what can be done if the employee claims to have a medical reason for not wearing the mask? Can the employer ask for a note? And there's been discomfort in that workplace because other employees aren't comfortable working with the person who refuses to wear a mask.
Yeah, well, the easiest one is the first question. If the employee doesn't cite some underlying health condition that interferes with their ability to wear a mask, the employer can say, go home, can't have you here. And that person would not be eligible for emergency paid sick leave, should not be awarded unemployment benefits. If you consider the construction context or a manufacturing context where steel-toed shoes, hard hats, eye protection, hearing protection, things like that are required, employers don't allow workers not to use those forms of personal protective equipment and remain at work. Employers need to, flex their muscles and take a stance with mask wearing in the same vein. It's a safety issue for the worker, him or herself, as coworkers. The state's guidelines clearly do say that employees cannot be required to wear face coverings if they claim they have an underlying medical condition that makes it unhealthy or unsafe if they were to use that face covering. My advice there is the employer needs to engage in a conversation similar to the accommodation conversation an employer would have in an ADA situation, and ask, what's the nature of the symptoms you experience if you were to use a mask? Do you get dizzy? Do you get disoriented? Is your vision blurred? Do you get shortness of breath? Because a face shield may be an alternate mechanism. Changing a workstation, arranging for remote work may be a possibility to explore that. If at the end of that conversation, it's concluded there is no alternate safety strategy to protect that person as well as others, I would say the employer would be within their rights to say, I'm very sorry, then we're going to have to ask you to leave the workplace. You can't remain here. The state's guidelines were revised recently with respect to customer and client service to clearly state that a customer that refuses to wear a face covering can be refused service. So the old, no shoes, no shirt, no service should be no shoes, no shirt, no mask, no service. And that's backed up by the state.
I'm going to paraphrase a couple of questions here. Do you have any advice on health screening? Can employers take temperatures or ask screening questions to employees returning to work? Should employees self-monitor? What are some privacy concerns around such?
And that's been actually that's died down a little bit, because I think a lot of employers have either gone ahead and taken temperatures, posed health questionnaires, asked people to fill them out before being allowed to come into work, and have somehow reconciled some of the difficulties associated with all of that. Those are clearly medical inquiries, as I said earlier, in the eyes of the EEOC, violating the ADA, but permissible in a pandemic context because of the direct threat that bringing that illness into the workplace could pose. But employers do have to recognize the limitations on temperature taking, because the CDC's clearly said some people with a temperature don't have COVID, some people have COVID but no temperature, and so it's not an absolute assessment strategy to identify someone's health status, nor are the questions. And taking temperatures does lead to who's going to take the temperature. How are we going to protect personal privacy? Because you don't want a line of employees at the front door, not socially distancing, waiting to have their temperature taken. And some are told go left into the workplace, and some are told turn around and go home. That's an inappropriate disclosure of people's health status. So, I think other companies have taken to asking employees to self-monitor on those items. And if someone is experiencing symptoms or is running a temperature and not coming to work, they get paid for that.
And keeping a safe workplace is really paramount for a bunch of reasons. I want to, it's 1:57 now, but I do want to spend a minute or two on the topic of schools reopening. It's kind of fitting. We started out talking about vacation ones, talking back to school. There's going to be a kind of a patchwork of regulations in Connecticut. Each school district is going to be making up its own decisions on whether, when, and how schools are going to return. Is it going to be remote learning? Is it going to be a hybrid between in-person or completely in-person? And employers are likely to face in the coming weeks scenarios where employers need to take or employees may need to take some time off to care for school-age children. There might not be any other resort. We might be back in remote learning land. Can you, maybe briefly give some suggestions on what employers can and should do to prepare for such situations? What's available to their employees? What do you see in the long term on this?
Boy, if I had a crystal ball or a magic wand, it could solve this maybe. But as we were commenting earlier, professional sports hasn't been able to sustain any type of games for more than a couple of days, where all of a sudden they're shutting down. I don't know what the schools are going to do. They're struggling with this, as you alluded to. There's a patchwork of guidance that's going to come out from one school district to another, between bus schedules, population density, all sorts of things like that. It's really unknown at this point. I've read some of the news reports that indicate a fairly high percentage of parents look forward to having their children return in person in the school setting. But they're going to be surveying them continuously between now and through the month of August. And I suspect that percentage may drop a bit if the infection rates continue to spike outside of Connecticut and bleed a bit into Connecticut. I think employers need to have extensive conversations with employees about alternate scheduling, continuing some remote work arrangements, parental plans for childcare, and looking to assist employees in identifying arrangements so that people can get back to work. And, it's unreasonable to ask employees to dump their kids somewhere where it's not safe and secure in order to get them back to work. But that's a problem. And hopefully the state will be working on that.
I hate to cut you off here, Mark, but it's 2:00 and we want to be respectful of everyone's time. I'd like to thank you for joining me today. It's good to see you, even if just over a computer. If your question was not answered live today, please know we will do our best to ensure you get answers within the coming days. I want to remind all of you that this session was recorded and will soon be available on CBIA's website. Thank you again, everyone, and take care.
Thank you, Brian. Enjoyed this. It's just like another day in the office, working from home. But these are questions that everyone is facing, and hope to continue to have these conversations. It helps me to get educated, to hear what's going on in the real world, and to fine-tune our guidance if we're giving answers to people. We at CBI have the luxury of giving the advice and saying, good luck, hope it works, and we hang up the phone. We want to hear if it's not working, let us know, and we'll try to come up with better answers. But also appreciate the comments from a lot of companies that have described some very innovative steps that they've taken to survive in this environment. So wish everyone well, stay safe, and this is the long game we have to play here. So continue to work at it, and be well, everyone. Thank you.